Good morning, everybody, and welcome to Coffee with Craig. We very much appreciate you guys tuning in and joining us as we talk about firearms policy, culture, gun culture, you name it. We're talking about it right here on Coffee with Craig. Please remember to like and share this video feed so that your friends can join in the conversation. And remember to subscribe to our YouTube channel and follow us on Facebook so that you can actually join the conversation while it is taking place live on Facebook and on YouTube. Also, please remember, go to fpcgear.com, fpcgear.com. It is a great way to support the Second Amendment and look good while doing it. Every dollar that you spend at fpcgear.com goes right back into the fight for our civil rights. So please check it out. Check out the new designs there at fpcgear.com. All right, let's get into today's topic. We're going to be talking about the courts. That's right. I realized I wanted to comment on this because I realized I totally skipped over talking about this and why it was so important. Now, I know that most of you, or at least most of America, does not live in the Ninth Circuit. Matter of fact, many of our listeners, whenever I talk about the Ninth Circuit, say, that's why I don't live over there. That's why I'm glad I'm not there. But the fact is that the Ninth Circuit Court of Appeals is the largest of all of the circuits. And as such, it's also one of the most liberal. And when I say liberal, irregardless of every other issue, let's talk about just the Second Amendment. When it comes to the Second Amendment, it's probably one of the, if not the most, anti-Second Amendment of all of the district courts. They basically see the Second Amendment largely as a privilege rather than a right, one that they believe can be heavily controlled and regulated, if not just flat out and outright banned. If in many cases, one could say if they had their way, we would be reduced to single-shot muskets. Just saying. That's maybe an oversimplification, but I'm just saying. Now, when President Trump ran for president, he said he was going to be one of the biggest friends of the Second Amendment as president that we've ever seen. My God, he's going to be great. He's going to be huge, just huge. And he's done some things appointed some justices that I believe are firm, strong supporters of the Second Amendment. But then again, he's also said some things that, that would lead one to raise question as to his commitment to the Second Amendment. Things like, take the guns and due process later. Not my words, his words. Anyway, all that having been said, one of the things that he's done that has also raised questions, because I've just learned that when it comes to President Trump, you can't judge him on what he says because he'll say just about anything, but you do have to take a look at what he does. And one of the things that he did was the nomination of a gentleman. His name is Mark Jeremy Bennett. He's the former Attorney General for the state of Hawaii. Now, in case you haven't guessed, Hawaii, not very pro-gun. In fact, it's easily in the top 5 of anti-gun states. I would even put it as potentially one of there's a solid argument for them to be number 1 when it comes to being anti-gun. Here's a guy who was the Attorney General. Now, he was nominated to the Ninth Circuit Court of Appeals by President Trump, which raises the question, what the heck are you thinking, Mr. President? Why would you think that this guy would be a good choice to support our right to keep and bear arms in a circuit, in a jurisdiction that is already anti-Second Amendment? Now, in case you wonder, why would you say this, Craig? Why would you say that this individual is anti-Second Amendment? Well, one only need look at his own words. Now, he wrote an amicus brief, a friend of the court brief for the state of Hawaii when it came to the Heller decision. You guys remember Heller, D.C. versus Heller, where basically they wanted to say that this individual didn't have a right to own a firearm in his own home. So this is what Mr. Bennett decided to write. He said, "We think that a decision that the Second Amendment prohibits strict gun control laws is just wrong." Now, what I am trying to figure out is exactly how strict gun control laws do not represent an infringement. I don't get how saying, yeah, no, you are not allowed to own a gun. not because you are a convicted felon or a convicted violent felon, not because you were convicted of domestic violence, not because you have a mental illness that may cause you to be a danger to yourself or others. No, you can't own a firearm because you've chosen to live in Washington, D.C. I don't see how that is not an infringement. That's not even a control. That's a straight up infringement of one's rights. Now, if you want to really understand what an infringement is, well, then let's just take a look at the definition. Now, I'm not one who believes in, oftentimes using modern day dictionaries in order to determine exactly what they meant when they wrote the words that they wrote in the Constitution, because we've seen how they've how they've changed the definition of words. So what I hope to do is I look to what did the words mean when they wrote them. So I always use Noah Webster's 1828. You can find it online. You can look it up, and that'll give you an idea of exactly what they meant when they wrote it. You can have an idea of what the words actually meant. So let's take a look at what it meant to infringe. Okay, so what it meant to infringe, it says here, to break as contracts, to violate, either positively by contravention or negatively by non-fulfillment or neglect of performance. So, in other words, what they're saying here is that you shall not break that, meaning you shall not take away someone's right to keep and bear arms. You shall not take it away. So if someone is in their own home and you say they cannot own a handgun for no other reason than the fact that they happen to live in a certain jurisdiction, how is that not an infringement? How is that not violating their right? How is that a non-fulfillment of the right granted to them, or not granted to them, a right confirmed by the Constitution? And yet this was an individual who was appointed or nominated by Trump and approved by a Republican Senate. Now, mind you, at least you got to note, only less than half of the Republicans voted for him. Less than half. But every single Democrat voted for him. Every single anti-gun, gun-banning, left-wing, liberal Democrat voted